If you are the left behind parent, so you would in effect be the applicant in proceedings under the Hague Convention, and your child has been taken or children has been taken from the country where they are normally what's called habitually resident. So that is the country where they live permanently, their life is, they are integrated into society there, etc. And you become aware that they have left the country, the wrongful removal, or you learn that they have been unlawfully retained in a country, again, without your knowledge or your permission, then the first step would be to contact the International Child Abduction and Contact Unit in London. They will then make contact with a panel lawyer, such as ourselves, who will be instructed to act for you within the proceedings, which are filed at the High Court in London. The first step would be to lodge the appropriate application. It depends how easy that is as to whether you know exactly where the child is. If you have an address for the child, it's far simpler. If you don't have an address but know that they are somewhere within the jurisdiction of England and Wales, then the immediate step to be taken will be to seek an urgent hearing and obtain various disclosure orders from a number of government agencies such as HMRC, DWP, NHS Digital, and so forth, who would be ordered to provide any address or details they would have for the child and indeed the parent who has brought the child into this country, to hopefully glean an address. At which point then, at the same time as obtaining the disclosure order, you would also obtain what is known as a location order, which enables the court tipstaff, which in essence is the court police, to confiscate the child and the parent who has taken the child's passport and travel documents, and also put on port alerts for major airports within the UK to prevent a flight risk if they were to then leave England and Wales. So it keeps them grounded in this country. At that point then you would serve that parent with your application and papers, and the court would list a hearing where they are ordered to attend and then say what they are going to say about your application. If we are acting for the respondent, so that is the party who is accused of abducting their child, then the applicant within those proceedings would have gone through the process I've just explained, and we would be instructed, once the respondent has been served with the application and papers, we would arrange a meeting and discuss what their options are and what the defences are that are open to them in terms of challenging such an application. Now, the defences, they are primarily threefold. The first defence is what is known as intolerability. So to give it its full term, it is that the child, if returned to the country where it's been taken from, will be placed at grave risk of harm and in an intolerable situation if returned to that country. To expand on that, a common factor is usually if there's been domestic abuse within the relationship and that the respondent is using that as an excuse to having left the country, that there was some concern as to the child's safety or his or her safety remaining in that country. The second defence is consent-acquiescence, which means that the party who has been left behind, so the applicant, knew about the move to a different country and consented to that, or since you've arrived in this country, their behaviour or they've done something to acquiesce, so show that they now consent to the permanent removal. The third main defence is child's objections, and that is that the child objects to a return to that country where they've been taken from. That isn't in such what's called a preference. So it's not that they would prefer to live in that country, it is a strong objection. Obviously, that is child age dependent. If the child is 2, then clearly they can't object. And usually any child below 7 years of age, it is not a viable defence to rely upon. If that defence is relied upon, then organisation known as CAFCAS, which is the Children and Family Court Advisory Support Service, they become involved. And they have a specialist team within the High Court, and they will be instructed to meet with the child and prepare what is known as an objections report for the court to say whether or not that defence is made out. The other defence, which is less common, is if there's any challenge to the child being habitually resident in the country where they've been taken from. As I say, that is a less common defence. The main 3 are the ones that I've just stated.